Hi, this is Jennifer Beckage of Beckage. And my one big thing for Incident Response 2020 is for us to respect that tension between data privacy and data security. Data privacy is about wanting to be left alone. And the concept of data security is protecting data from unauthorized actors. Sometimes the two concepts work together, and sometimes they conflict. As attorneys in incident response, we're helping businesses deal with that tension between data security and privacy. For example, new and emerging privacy regulations are encouraging bad actors to submit data subject requests to access and manipulate data in furtherance of a larger data breach. So we always need to strike that balance between data privacy and data security.
Thanks, Jennifer, for that one big thing, and thanks for that amazing discussion of ransomware to the prior panel. Ransomware is a real scourge that is not going away anytime soon. I'm seeing more and more big-time practitioners take it on. Two other hurdles that are not going away anytime soon are the GDPR and the California Consumer Privacy Act, which are these mammoth regulations impacting everything that happens during an incident response. Even though they're both in their infancy, each is broad and far-reaching in scope and power, and that's why we have this next panel to sort of give you some clues as to how to deal with it. So who did we find to moderate a panel on something so new and so challenging? Well, Travis LeBlanc, a partner at Cooley, who is the LeBron James of cyber and a lawyer who prides himself on thriving amid the juxtaposition of cyber, technology, law, and business. I love Travis's career because it began in communications. He was an investigations and litigation lawyer, and he made his bones as chief of the FCC's Enforcement Bureau during the Obama administration. It's a very important job, and he was quite something when he was the FCC, Federal Communications Commission, enforcement chief. I watched Travis recently on a YouTube video from Black Hat entitled Crumbling the Super Cookie and Other Ways the FCC Protects Your Internet Traffic. And Black Hat is sort of like the opposite of the incident response forum. Everybody's in T-shirts and hoodies and everything. And so most government lawyers just don't want to be there or are very intimidated, but not Travis. He leaned in. In fact, he did the speech in a black hat, a baseball cap with a logo from the FCC. Just terrific. Thanks, Travis, for being here. And I'm looking forward to hearing the status of these new regulations from you. And welcome.
Thank you, John. Great to see you.
Excellent. Next up, we have Jennifer Beckage. Jennifer Beckage of Beckage PLLC is a force of nature. So many of us here share the common thread of not just being legal or compliance professionals, but also entrepreneurs. Every panelist today never went to law school with the thought that, hey, I'm going to do cyber. But we're creating a practice area that really only recently experienced its genesis. But very few people here have taken that notion of entrepreneurialism to its highest level, except for Jennifer Beckage. She's a partner and the founder of Beckage PLLC, and her law firm is exclusively dedicated to cyber. And that wasn't even her first company. She also founded a tech startup called EdgeNet that developed internet-based programs and other cutting-edge web technologies for NASA's Kennedy Space Center to the Buffalo Bills and the Sabres. Based in Buffalo, Jennifer shows us all, just how high we can set our aspirations, and that not every incident response icon has to be from some big metropolis. Hope all is A-OK in upstate New York, Jennifer, and welcome back to the forum.
Thanks. Great seeing you.
Excellent. Next up is Serrin Turner from Latham and Watkins. He cut his teeth as an AUSA, an assistant U.S. attorney in the Southern District of New York, where he also served as the lead cybercrime prosecutor there. And what makes his perspective so fascinating is that he actually led two massive and complex federal prosecutions. First against Silk Road, which I mentioned earlier, where Justin Herring handled some of the state charges there, which was this vast online black market for illegal drugs and other contraband. And second against Liberty Reserve, a multi-billion-dollar money laundering digital currency service and underground bank for cyber criminals across the globe. Really fantastic prosecutions that were both the first of their kind. So welcome, Serrin. Looking forward to hearing you talk about GDPR and CCPA and the rest.
It's great to be here.
Excellent. And finally, we have James Trilling, who is a senior attorney with the Federal Trade Commission's Division of Privacy and Identity. And again, what we try to do is have somebody from the government on these panels to really give you the government's perspective, which is so important during any incident response. He played leading roles in the FTC's recent hearings on artificial intelligence, data security, cryptocurrency, and privacy. His caseload includes such notables as FTC actions involving Uber, Wyndham Hotels, and cyber spy software. He also works on the Internet of Things at the FTC, where the tension to provide multiple levels of connectivity can create real privacy challenges. One thing for certain is that the FTC has emerged as a major player in the incident response space, bringing a broad swath of enforcement actions and very, very active. So, Jim, really welcome to the forum, and thanks for helping to keep us all from having any problems with respect to the internet. Anytime my internet connection goes down, I feel like it should be your fault. Is that an accurate thing to say?
Absolutely. We're 100% responsible for,
Thank you.
For that.
All right, Travis, take it away. I'm going to get the next panel ready.
All right. Thanks a lot, John, for that introduction. And good afternoon, everyone. It's exciting to be back at the Incident Response Forum and to have the opportunity today to join Jen and Serrin and Jim in this important conversation about the evolving incident response regulatory landscape. 2 years ago, we were preparing for the onslaught of Europe's General Data Protection Regulation and the sea change that law brought to privacy and data security, not only in Europe, but also abroad, and especially here in the United States. Last year, we again found ourselves in the throes of a new regulatory regime in the United States with preparation for California's Consumer Privacy Act. Both of these statutes are having a tremendous impact on businesses and will permanently change the way customer data is collected, stored, and used. We're going to dive into both of these regulatory regimes during this session, as well as the FTC's recent activities around incident response. I'm planning to monitor the chat box in real time during the session. If you have any questions, please feel free to type those into the chat, and I'll try to ask as many as I can throughout the session. With that preliminary aside, let's go ahead and jump in. As I indicated, over the last couple of years, not only have there been many regulatory changes, but there have been numerous conference sessions across the country that have gone into great detail on all provisions of the California Consumer Privacy Act, particularly those provisions that are ambiguous and those that are less ambiguous. Today, however, we want to focus our conversation on how the CCPA impacts incident response. In that regard, Serrin, can you highlight for us the key provisions of the CCPA with respect to incident response?
Sure. Thanks, Travis. First, it may be useful just to clarify what businesses the statute applies to and the breadth of the statute scope. Contrary to what the name might suggest, it's not just limited to companies that physically reside or operate in California. It applies to any for-profit entity that has more than $25 million of revenue or generates more than 50% of its revenue from selling personal information. But most importantly, it applies to any business that annually purchases, sells, shares, or receives any personal information for more than 50,000 consumers in California. And the key word there is receive. So that can mean simply receiving information over a website that you operate. And the sort of information we're talking about is very broadly defined to include any information that can be linked to an individual, like somebody's IP address. So if you run a website that is visited by more than 1,000 people per week from California, and you collect those IP addresses like you normally would when you're logging your traffic, you're covered. And what the statute focuses on is limiting businesses' ability to sell personal information and giving consumers the rights to access and delete their data. But it does contain some security provisions. One security provision, for example, exempts security-related information from the right to delete their information. The business doesn't have to delete information that it needs for security purposes. But for the key provision for incident response is a provision that recognizes a duty on the part of covered businesses to implement and maintain reasonable security procedures and practices, procedures that are appropriate to the nature of the personal information that are maintained by the business. Now, fundamentally, that is nothing new. states have essentially been enforcing a duty to maintain reasonable security practices through their general consumer protection laws for years. But the CCPA uniquely frames this duty in specific terms as a duty to maintain reasonable security procedures. And most important, provides two new ways of enforcing this duty. First, it allows the AG, the state AG, to bring a civil action for injunctions and penalties under this new law. It provides that they can seek penalties of up to $2,500 per violation or $7,500 per intentional violation. It's not exactly clear what per violation means, but in all likelihood, it's going to be interpreted to mean every consumer who's affected by an incident, that's going to be a violation as opposed to applying to the incident in the aggregate. So that's going to add up very quick to large potential penalties. Another important aspect of the AG civil lawsuit remedy, though, is that the AG can only sue after they've given a company 30 days to cure whatever the security violation is. And it's sort of unclear what that's going to mean in practice. Is that an opportunity? Is that just an opportunity to cure whatever security deficiency led to the incident, patching the vulnerability or fixing whatever system's at issue? Or is it curing the harm or potential for harm that might be done as a result of the incident, which is obviously a much greater challenge for businesses. And the other means of enforcement is through a private right of action. And Travis, I can stop there and pass to Jennifer if you'd like.
Well, let me just add on one additional one, which is little known and unwritten in the statute, but an area where we expect to see some activity around enforcement is the use of the CCPA by cities and counties in California, district attorneys, using their authority under the Unfair Competition Law, Business and Profession Code 17200 and 17500, to what we'll say backdoor enforce the CCPA. There's an express prohibition in the statute that limits the ability of a private entity to enforce the CCPA under the Unfair Competition Law, but that prohibition is against private entities, not public entities like city attorneys and district attorneys and county attorneys. And we fully do expect to see at some point soon that cities and counties will show up to the table to seek to enforce all provisions of the CCPA, oftentimes represented by plaintiffs' counsel, who will often work on a contingent fee basis on behalf of cities and counties. This is actually bread and butter consumer protection work that cities and counties do with partnerships with plaintiffs' attorneys. So it's just another area to keep in mind as companies are thinking about the litigation risk resulting from a CCPA violation. But as Serrin teed up, Jen, if there is one provision of the CCPA that almost everyone in the business world knows, it's that the CCPA contains a private right of action for data breaches. What is this private right of action, and can you give us any insights into how it operates?
Right. Currently, the CCPA does provide a private right of action, but again, it's only in the data breach context or the disclosure context. And I mentioned disclosure because of the recent case that was just filed against Zoom, where there wasn't a data breach, but it's alleging that there's a disclosure of data from Zoom to Facebook. So, and I know we'll talk a little bit more about some of the current litigations. But I say that the CCPA currently provides a private right of action because we don't expect those final version of the regulation until the summer. So what do we do? So consumers who have non-encrypted or non-redacted data that was subject to a breach or disclosure, and that PII is accessed or acquired, they may institute a civil action for the company's breach. So it's kind of like one of those choose your own adventure books, if you will, for the plaintiffs. And I don't know if anyone remembers those, and I'm probably dating myself, but they sort of have three different paths. You don't remember those, Travis?
Oh, I do remember them. I think of the CCPA as one big choose your own adventure.
But with those, the plaintiff has a few different options. So one, if they're aware of an incident, they can provide written notice to the company of the specific provisions of the CCPA violated. And then that company has 30 days to cure. And we'll talk about cure in a little bit, and Serrin already talked about that a little bit ago. If the company cures, or if the company doesn't cure, then you can proceed to a civil action and seek statutory damages. If the company does cure, then you can't seek those statutory damages as you go forward. And I'm so sorry, I've had a cold with allergies, so excuse my throat. So if the plaintiff doesn't want to pursue statutory damages, they could just go forward and proceed with litigation and just seek actual damages. So a couple questions arise. How do you cure? Within 30 days of receiving a notice, this company must respond in writing, setting forth that they've cured. First, I would take a look at that notice that you receive and make sure you're actually responding to a cured letter. Investigate internally who's making this request. Gather some intelligence on that potential plaintiff. And I would keep an eye out for other multiple data subject requests. Are we seeing any trends? What are we seeing, like an increase in multiple DSAR requests, data subject requests, perhaps for deletion, because we sometimes see that around a data breach. Is this just a fishing exercise for more to try to find another CCPA violation? So I would first go through those questions when you receive one of those letters. And then, as Serrin mentioned, you have to identify what is a sufficient cure. And the statute doesn't define what is a sufficient cure. So the statute says that under the CCPA, the company must state that the violations have been cured so that no further violations shall occur. But is simply ending the breach enough? As Serrin mentioned, blocking those access to hackers. If you had an unintended disclosure to a third party and they're a known party, you could get some sort of declaration or attestation from them that they've deleted the information, they never looked at it. Maybe that's a sufficient cure. If we look at the CLRA and other statutes, are we going to say that some sort of monetary compensation, some sort of payment is going to be a cure? These are all still a lot of questions that unfortunately just aren't answered. And again, think about procedurally when you're getting this notice to cure. You may have had an incident, provided a data breach notice letter, and then it could be sometime after that you get this notice from a plaintiff or potential plaintiff. You could get these on a rolling basis too. So it's a little bit of whack-a-mole perhaps when you're receiving these letters. And I'll be honest with you, as a former tech business owner and worked on numerous breaches, 30 days is not a lot of time to be able to make a lot of assurances or promises as to what the future is going to look like. So I would suggest that companies start to look now as to what sorts of things they should potentially put in a cure letter. Don't wait until you get a notice of cure. We already talked a little bit about the AG's involvement and how the AG can pursue penalties and fines under the CCPA. When a plaintiff currently under the statute, when a plaintiff does file an action, they have to provide notice to the AG, and the AG can decide whether to get involved in or not. A couple other quick things, Travis. As far as who has sort of standing to bring this claim, you're not looking at the definition of personal information under the CCPA. You're really looking under the definition of personal information under the California's data breach statute, which is being expanded to include things like biometric data. And just like we saw in Illinois, we're going to see a lot of increased litigation surrounding that as well. So, obviously this is a very interesting time right now to see how plaintiffs are going to pursue these private right of actions, how companies are going to respond when they're asked to provide some sort of promise about a cure, opening themselves up to further potential litigation if their promises end up not being achieved. And, of course, that $1 million question is, this is supposed to be a private right of action where there's some sort of breach of reasonable security measures, but that's not defined. And that's leaving open for litigation, for the lawyers to flesh it out, and also, leave a lot of confusion as to how that's going to be interpreted.
Jen, thanks for that background. I mean, you not only was it extremely thorough and helpful, but you anticipated a question that we got from one of the folks in the audience about the standing issues that could arise from this. Unlike a lot of other private rights of action, this one does contain a statutory damages, which is a minimum amount of $100 per violation up to $750 per violation, irrespective of whether or actual damages, irrespective of whether or not the plaintiff actually experienced any pecuniary loss. And a lot of the litigation that we've seen in the federal courts has really been about whether or not there was sufficient injury to the consumer plaintiffs to be able to sustain Article 3 standing. But what the CCPA attempts to do is, is to make that irrelevant by saying that consumers, California consumers, are automatically entitled to statutory damages.
Right. It's going to fast track that litigation, and all those potential plaintiffs are going to try to pursue statutory damages. So they're going to try to issue that notice to provide that company that opportunity to cure, because they don't have to provide or prove that actual out-of-pocket losses, and that's going to help fast track that litigation. So it will be interesting to see how this sort of plays out. And we're already seeing some litigation around some of these issues. Another thing that I was going to mention is, as it relates to damages, let's say you are able to pursue with statutory damages, you can also achieve and receive actual damages only if they exceed the statutory. You also can get declaratory judgment or injunctive relief, or any other relief that the court deems proper. And here will be interesting to see, if that includes attorney's fees, what that might be included.
Yeah, as sort of previewed, there have been some cases filed. And Serrin, should companies who operate in California and face a breach worry about an onslaught of CCPA litigation from the plaintiff's bar? Have any cases been brought to date that include CCPA claims? And, interestingly, have they been only in state court? Or are we seeing some in federal court? And whether these standing issues come into play when California consumers seek to pursue CCPA claims in federal court?
Well, in terms of whether there'll be an onslaught, it's an interesting question, because like was just being discussed, the statutory damages is the obvious incentive here. That's the real game changer. This is the first data breach statute of its kind to offer statutory damages. But at the same time, there are real limitations on this right of action. As was mentioned, the definition of personal information that has to have been affected is quite narrow. It has to be Social Security number, driver's license number, financial account credentials, or medical or biometric data, and that's pretty much it. There's a lot of breaches these days don't affect that sort of data, but are engendering lawsuits. Those lawsuits could not be fashioned as lawsuits under this CCPA provision. And moreover, you do have the notice and cure provision, and a lot of plaintiffs want to rush into court right after the breach has been announced. You can't do that under the CCPA. You have to give a company 30 days written notice. Then what if you get a response back saying that the deficiency's been cured? So that issue has to be worked out. But certainly, you're going to have the plaintiff's bar doing the best they can to take advantage of the statutory damages provision of the statute. We've seen a couple cases brought to date that either are bringing specific claims under the CCPA or are trying to piggyback onto it. So you had the Hannah Anderson and Salesforce breach. It was a PCI breach, and a case has been brought with respect to that breach. It does not include a CCPA claim, but tries to bring a UCL claim, unfair competition law claim, that's predicated on the CCPA. It's very doubtful that strategy is going to work. As I think, Travis, you mentioned before, the statute does prohibit the CCPA from being used as a basis for any other cause of action. So that's likely going to be dismissed. There's also been a case brought with respect to a breach of healthcare data that does affirmatively plead a CCPA violation. But there, the plaintiff is not a California resident, and under the CCPA, consumers are specifically defined as California residents. There is no notice and cure provided, which has to be provided before a case is filed. The breach occurred before the CCPA effective date, so another basis for it not being the CCPA not being applicable. So you're seeing, plaintiffs' counsel trying to do some early experimentation with the CCPA. These are probably ill-fated attempts, But there's no doubt that this trend is going to continue. And the big issue, like you say, is going to be whether courts are going to find Article 3 standing based on this statutory damages provision, even where the plaintiffs might have a hard time showing actual harm, in the absence of that provision. So the Spokio issues that remain unresolved, the way that Supreme Court decision, this is going to surely be a catalyst for litigating that issue further in this specific context.
Yeah, with the CCPA, already in effect, with the Attorney General getting the ability on July 1st to enforce all the provisions of the CCPA, given the private right of action, the prospect that cities and counties would be in the game, that there's a real possibility that a company could find itself after a breach in the wake of a whole series of investigations from state, possibly even federal, local, and private entities. Serrin, do you have any tips or for managing or advice that you might be able to give to folks for managing all these parallel proceedings?
Yeah, sure. So whenever you have a breach that affects people in multiple jurisdictions, state or national, there is always the risk that you're going to have inquiries from a number of different regulators. Plus, you have the potential for private lawsuits. That risk isn't new, but it's certainly heightened under the CCPA, and with the additional private lawsuits going to be brought, and the sort of incentive it provides for the California AG to bring investigations. So you're going to have certainly a heightened risk of parallel investigations. And what I would suggest, I think the key for handling parallel investigations is consistency, ensuring that facts are portrayed the same way to different regulators. And that may sound simplistic, but it's harder to accomplish than it may sound. You get questions from regulators at different times. The understanding of the attack, the incident may change over time. Each regulator may have some different issue that they're focused on. And the risk that creates is it's not uncommon for regulators to share information with one another. And if the information given to one regulator seems significantly different from the information given another, that is the sort of thing that can engender skepticism and distrust or a lot further inquiries by regulators. So the best way to prevent that is to be proactive rather than reactive. You want to do a very comprehensive investigation into the facts from the outset. You don't want to just react to individual questions as you get them from regulators. You want to anticipate their questions, develop like a thorough, consistent narrative, one source of truth that you can draw from in answering all these regulatory inquiries. And as the company's understanding of the facts do change, you want to make sure to update the regulators that you work with to date to apprise them of that, so they're not caught by surprise, by some disclosure to another regulator. And the last thing I mention is that you need to keep in mind that any regulatory submissions that you make could potentially be discoverable in private litigation, which usually follows a few months down the road in terms of discovery from the regulatory proceedings. So you always have to keep that in mind and make sure your regulatory and litigation defenses are synced up.
One thing that I'll add is, during all of this too, you may be receiving, tons, if not thousands, of data subject requests. So you're going to have to be responding to those and handling those within the timeframes under the CCPA, in addition to handling these investigations and potential litigation.
I'm going to jump in there too. Serrin gave some good practical tips, that I would echo from the civil law enforcement regulatory perspective. The other thing I would add to that is, tell us early as defense counsel or the company that's under investigation, if you are being investigated by other civil law enforcement or regulatory agencies, and we may be able to factor that in terms of the items that we're requesting in our civil investigative demands. We may be able to factor that in terms of deadlines or the scope of requests. We have an interest in conducting investigations efficiently too, but we need defense counsel and the subjects of the investigations to be a part of that in letting us know things that they'd like us to consider doing in light of other investigations.
Well, Jim, that's mighty reasonable of the
We're always
the
reasonable,
commission.
Travis.
Well, speaking of reasonable, Jim, let's talk about reasonable security. Underlying the CCPA is the principle that companies should maintain reasonable security. And this isn't just true of the CCPA, it's even a bedrock principle of FTC data security precedent. And Jim, although you're obviously with the FTC and not charged with enforcing the CCPA, you are a regulator. And in assessing what is reasonable security in the wake of a breach, what sorts of documentation and controls do you expect to be in place? Do you think that courts would have the same expectation as do regulators as to what kinds of documentation and controls are considered reasonable?
Good question. So the FTC has long emphasized that reasonable security is a process-based approach of identifying risks and implementing controls to address them. In assessing reasonableness, we consider factors such as the nature and sensitivity of the data that the company has collected, the size and complexity of the business and its data operations, and the cost and availability of tools to reduce vulnerabilities. If you look at the body of FTC cases and guidance and the body of work that the state AGs and other civil law enforcement and regulatory agencies have created, you see a lot of commonalities in the types of problems that civil law enforcement and regulators have pointed to in terms of unreasonable security. So if you look at that body of cases, you have a good idea of the types of documentation and controls that we are likely to ask for at the FTC and that our peers in the states and elsewhere are likely to ask for. We're likely to ask for basic documentation such as risk assessments, data inventories, and maps, the company's written data security policies and procedures for a range of issues, including patch management, anomaly and intrusion detection, authentication and access management, monitoring and logging that is used to identify incidents or suspicious activity, document retention policies, deletion practices and procedures. We're also going to want to see documents that evince monitoring of compliance and implementation of the written practices. We're likely to seek training materials, vulnerability assessments and tests and penetration tests, as well as documents showing plans to remediate the issues that are identified in those tests. We're also likely to request documents showing what the company is doing to monitor security alerts and bulletins that may come in from vendors and from others regarding software and hardware that the business is using in its environment. We certainly also are going to request information about claims that the business made about its security practices, and we're going to want to see documents that show that there was a basis for making those claims and that the company's practices are actually consistent with the claims. That could be everything from the basic statement, that we encrypt X type of data, to statements that might be made about implementing other types of specific security practices. We're also going to be looking for documents to show what type of due diligence the business did in selecting vendors or service providers that might have a role in processing or securing the business's data. And although we certainly do investigations and bring cases where there hasn't even been a breach or an incident. We're going to want to see evidence of the company's incident response plan and evidence to show that it actually practiced that plan over time. So in terms of controls, we're going to want to see controls in place that match the types of issues that I mentioned that we're going to want to see documentation of. And then in assessing reasonableness, industry standards can certainly also be relevant. And I do expect, going back to your question, Travis, that a court would be looking to many of the same factors and types of controls that I've identified. And certainly in a litigated case, we would expect that those factors would be the subject of expert testimony.
Yeah, I mean, Jim, that's a pretty scary list that you just went through of what measures you would consider in evaluating reasonable security. And, for the billion-dollar companies, I can understand coming up with such a complex compliance regime. But what do you say to the much smaller companies out there, the companies that have, 2 people that can focus on privacy and security? I mean, how do you look at them in evaluating what's reasonable for the nature of their business and the size of their business?
Well, just as important as the size of the business is certainly the nature and the sensitivity of the data that the particular business is collecting. So if you're a small business and you're collecting the most sensitive data, you still need to have controls in place to protect consumers from the possibility of a compromise of that data. And not everything that I named is an expensive issue to address. If you're a small business, you certainly can and need to have access and authentication practices in place. You still need to be doing things like considering encrypting data and segmenting data that you're collecting from the internet or from systems in your business that don't need to access the data. Of course, we're going to look at the totality of the circumstances when investigating any business. So there may be differences between the expectation of the multi-billion-dollar business and the 2-person business, but not to the expense of considering the nature and sensitivity of the data that 2-person business has decided to collect. The other thing I would mention is that we do have FTC guidance, particularly tailored to small businesses, including to help small businesses think about issues when it is selecting vendors, from things ranging from setting up websites to perhaps providing virtual networks and providing email related services. And I would highly encourage council and small businesses to look at those particular resources. And then also resources that the states, DHS, CISA, the Small Business Administration, NIST, and others publish specifically for small business.
As we transition from the CCPA over to the federal landscape, Jen, we've gotten a bunch of questions that are coming in about what to anticipate around new potential legislation in the future, whether that's at the state level or at the federal level, and in particular, whether there's a possibility for federal comprehensive privacy legislation. Do you have any thoughts that you might be able to share with the audience on that?
I'm sorry, did you say Jim or Jen?
Jen.
Jen, yes. I think that there's a few things that are going on. You have the GDPR, you have the CCPA. We're seeing sort of this rolling effect of the CCPA with a lot of different states moving forward with different legislation that will look somewhat like the CCPA or something like the GDPR, but everything's a little bit different. As far as a federal privacy scheme, that's the $1 million question as well. What are we going to finally have some sort of overarching federal privacy scheme? There's a few that are at play right now. There's a Consumer Online Privacy Rights Act, which has been proposed, and the U.S. Consumer Data Privacy Act, which has been proposed. I think that the big tie-up with what this will look like from a federal level is really, is there a private right of action that's going to be afforded? And is there going to be any sort of preemption of any stricter state laws? So, the landscape of the U.S. laws is still sort of in flux. And, as a business, it's very difficult to sort of identify what that future is going to look like and what I should do to protect my information, because there's so many different standards out there, and hearing, Jim go through that really long list, as Travis mentioned, that's a lot for a small business, or in a medium-sized business. It's important, and they're doing their best that they can. But especially in this current landscape with the pandemic, their whole enterprise has shifted to a distributed workforce. It's constantly evolving. There's constant changes, but yet you're sort of always, asked to meet this certain threshold, which is, very taxing and time consuming and expensive for companies, who I think at the end of the day are really doing the best that they can.
Yeah, I think it's certainly looking like there's not going to be any immediate federal legislation that's about to be passed in the near future, which leaves us with the Federal Trade Commission as the default authority on what constitutes enforceable privacy and security practices. Jim, can you give us a little bit of background over the last year, and in particular, what the FTC's been up to around data security? And we definitely cannot leave here without hearing about your thoughts relatively quickly on LabMD, and I'm sure that Serrin has some equally compelling thoughts about that decision.
Okay, so we have, at the FTC, we've remained very active in the data security space in the last year, including all of the core pillars of our work. So investigations and enforcement, policy work, and also business and consumer education. In 2019, I think we announced 7 or so cases that had data security counts, and we have announced 2 so far in 2020. In January, the Commission announced a settlement with a mortgage broker in a case that includes allegations that the company violated the Gramm-Leach-Bliley Act by failing to implement an information security program and then failing to test the program after implementing it. And then just last week, the Commission posted for public comment a proposed administrative settlement in a data security case against a Canadian company that sells internet-connected locks. And the complaint in that case alleges that the company made deceptive claims about the security of the locks and also the company's practices for securing the consumer data that its mobile app collected from the consumers who used the locks. In terms of keeping track of the cases, there is a press release for every case, and I also would highly recommend that practitioners and other stakeholders subscribe to our business blog. There's a business blog post virtually every time there's a privacy or security case announced, and those business blogs provide additional insight into the cases beyond what somebody might read in the press release. And then also, as a reminder, all of our proposed administrative settlements have public comment periods. So that's another opportunity for stakeholders to weigh in on our work. In terms of things to note from our work in the last year, and this does follow the 11th Circuit decision in LabMD, which Travis had alluded to. We have taken steps in the last year to revise some of the language that people are used to seeing in the bulk of our data security orders. So the bulk of our data security orders require the company that's being placed under the terms of the order to maintain a comprehensive information security program and to have biennial independent third-party assessments of that program. Three things that I would highlight in terms of language revisions in orders that the Commission entered into in 2019 and after. First, the revised order language adds specificity in terms of what a company under order must do in its information security programs. And typically, there are specific safeguards enumerated in the order that match back up against the types of security problems that were alleged to exist in the complaint. The second thing is that the revised order language also increases accountability of the third-party assessors by giving the FTC the authority to approve the assessor selected for each assessment, and then also by requiring the assessors to identify in their biennial assessments the evidence that supports their conclusions, including independent sampling, employee interviews, and document review. And there's also language in the order that precludes the assessors from refusing to provide their working papers to the FTC on the basis of certain privileges. And then the final thing I would highlight in terms of the revised order language is language that elevates data security considerations to the C-suite and board level, which I know has been covered in earlier panels today. So under the FTC orders, every year, the company under order must present its written information security program to its board or similar governing body, and senior officers must provide certifications of order compliance to the FTC when their companies are under these data security orders. A couple of other things I want to note very quickly on the policy side. The FTC's proposed revisions to the GLB safeguards rule remain pending. We do have a workshop scheduled for May 13th on that issue. Watch the FTC website for a potential announcement of any postponement of that workshop due to the coronavirus pandemic. Also would encourage people to attend PrivacyCon in July, and also we've all recently announced a workshop on data portability that will take place in September.
Thank you, Jim. That was great background on the activities that the Commission has been up to over the last year, and I'm sure that the remainder of this year and next year will prove to be equally interesting to follow for those of us on the other side. We only have a few minutes left, but before we do, I do want to at least touch on the GDPR for just a minute and give both Serrin and Jennifer some time to sort of, if you had an elevator pitch that you could give to any company about the GDPR and incident response, and you had 1 minute each, what would you tell them?
From my perspective, it would really be to be well prepared, to practice this ahead of time, to have that consistent message and consistent approach, be prepared to have parallel investigations, be thinking about litigation, but really prepare. That's really the best way when you're thinking about the GDPR, especially in light of the CCPA and other international data security and privacy regulations.
I would add the 72-hour notification requirement is likely to be a major focus of any GDPR regulatory inquiry. Regulators often, from what we've seen, want a very fine-grained detail to show that you're in compliance with that requirement. So once you have an incident, make sure you understand when you understood the incident began and keep track of when exactly those 72 hours are going to expire, because that's going to be getting very close to it.
Well, I see Bruce has joined us. Thank you to Jen, to Serrin, to Jim for this engaging conversation around the regulatory landscape and incident response. And Bruce, I'm going to turn it back over to you.
And thank you, Travis, for doing a great job with this panel, and to the entire panel, and to the FTC, thank you again for your perspectives. Really appreciate it. Our next panel is on cyber insurance and class actions. It starts at 3:25. We'll see you back here in a minute. Thank you.